Welcome to The Explainer. Today, we're going to talk about something that's incredibly powerful, often invisible, but shapes our lives every single day. We're diving into administrative law.
So think about this. Who actually has the power to approve your driver's license or to deny your benefits? And maybe more importantly, who checks them? So many of these critical decisions aren't made by politicians we see on TV or judges in a courtroom. Nope. They're made by government departments, local councils, and all sorts of regulatory agencies. This explainer is all about that massive, sprawling power and the crucial legal system that's supposed to keep it all in check.
I mean, just look at this list. It's everywhere, right? It's the local council saying yes or no to that extension you want to build. It's the agency that decides if you get Social Security. It's the board that can grant or even take away your professional license to do your job. This is what we mean by the administrative state. It's working all around us, all the time, making these huge calls that affect our lives, our work, and our communities.
Okay, but what happens when that power goes wrong? When it's used unfairly? Or maybe the person making the call is just incompetent? What happens when a decision feels just plain wrong? This gets to the very heart of why we even have administrative law. It exists to solve this one huge problem: the potential for what lawyers call maladministration. And that is exactly where administrative law steps in. As the quote says, its whole purpose is to promote good administration. See, it's not just a rule book telling the government what it can do. It's so much more than that. It's a detailed guide for how it has to do it. You can think of it as a kind of shield for the citizen, designed to make sure we get fairness and competence from people in power. All right, Section 1, review, not a redo. So if you're a citizen, how do you actually challenge one of these decisions? Well, there's a primary tool for this, and it's a real cornerstone of the rule of law. And that tool is called judicial review.
Now, here's the key thing you have to understand. This is not about asking a court to remake the decision for you. Instead, it's about asking a judge to check the process, to make sure the decision was made properly, legally, and by the book. It is an incredibly powerful tool for holding power to account.
Okay, this distinction is super important to get straight. An appeal is totally different from a review. An appeal asks, was the decision right? It's all about the merits of the case, and a judge can actually substitute the original decision with their own. But judicial review, it asks a very different question. Was the process lawful? It's all about legality. A judge can't just swap in their own opinion. They can only say, whoa, you didn't follow the rules here. Go back and do it again, but do it right this time.
I love this analogy. It makes it so clear. A judge in a judicial review is basically a referee in a sports match. The ref doesn't play the game, right? They don't decide who should win the match. Their only job is to blow the whistle when someone breaks the rules. That is exactly what a judge is doing here. They're not making the government's decision for them. They're just making sure the government played by the legal rule.
Okay, so Section 2, the rules of fair play. What exactly are these rules of the game that a judge is enforcing? Let's break down the specific grounds a court can use to say, nope, that decision was unlawful. First up, we have illegality. This one's pretty straightforward. It's when a public body does something it simply has no legal power to do. Lawyers have a great Latin phrase for this, ultra vires, which literally means beyond the powers. So, for example, if an agency was given power by law to regulate food safety, it couldn't suddenly start regulating traffic. That would be ultra vires. Second is something called procedural impropriety. This is all about basic fairness, what are often called the rules of natural justice. There are two big parts to this. One, you have a right to a fair hearing. You get a chance to make your case. And two, the decision maker must not be biased. They can't have a personal or financial stake in the outcome. You know that old saying, justice must not only be done, but be seen to be done? That's what this is all about.
And then there's the third ground, irrationality.
Now, this one is a really high hurdle to clear. It's for a decision that is just so illogical, so absurd, that no sensible authority acting reasonably could ever have made it. We're not talking about a decision a judge simply disagrees with. We're talking about a decision that completely defies the logic itself. Okay, moving on to Section 3, a constitutional tightrope. Now, these grounds, illegality, procedural issues, irrationality,
They sound pretty clear on paper, right? But when you actually try to apply them in the real world, well, that's when things get tricky. It reveals this deep tension, a kind of constitutional tightrope walk at the very heart of our democracy.
And this tension is captured perfectly by these two competing theories. You can think of it like a traffic light. The red light theory sees administrative law as a brake, a stop sign. In this view, the courts are there to check government power to stop the state from going too far. They're almost like combatants. Then you have the green light theory. This view sees the law as a way to guide and facilitate good government. The courts are more like collaborators, working with other parts of the state to help the whole system run smoothly and effectively.
And this quote from Lord Mustill really gets to the heart of that tightrope walk. He says the courts have to interpret the laws and make sure they're obeyed, but sometimes that means they have to step into the territory which belongs to the executive. It's such an incredibly fine line they have to walk. Their job is to hold the government accountable to the law, but without becoming the government themselves.
And so all of this leaves us with this final, critical question. How do we ensure fairness from our government without putting judges in charge of governing? This isn't just some abstract legal puzzle. It's the constant challenge at the core of administrative law. The system isn't designed to paralyze government, but to make it better. And how we as a society strike that balance, well, that defines the relationship between the citizen and the state. It's something to think about.